Is this on? Good evening. This is the regularly scheduled meeting of the Warren Planning Board, January 22nd, 2024. Jim Lefferts will be absent. He had informed me that he would not be here. Otherwise, the rest of the board is here. Last week, we lost Matt Atwood and Brett Bobine. And Terry De La Paz, who was an alternate, has been appointed a full member of the planning board by the town council at their last meeting. And so we do have a quorum here. We are approving the minutes from, and I will do this one at a time. And we'll start at the closest one, 1/3/2024. I believe there was a correction made to that. The correction was, it was an relative to the size of the parking spaces at Liberty Street, which was 8 feet, but it was actually 9 feet in terms of the length. So that was the only change, I believe, that was made to it. I'm sorry, what? Width, 9-foot width. Right, yeah, because we're not talking about
What you drive.
and my days of driving Austin Minis are over. So could I have a motion to approve the minutes as amended for the January the 3rd, 2024? Tyler, second. Mike, all in favor? Aye. Those opposed? Okay, 12/18/2023. I didn't see any need for any corrections on those. By the way, congratulations and kudos to our lovely Secretary Haley, who has done an unbelievable job on this, given the amount of talk. 12/18, could I have a motion to approve those? Tyler, Mike, all in favor? Aye. And finally, 11/9/2023, that was referencing the Technical Review Committee minutes. Again, no changes to those. Motion to approve.
Mr. Chairman, just to
Yeah,
interrupt
sorry.
before the motion comes out, is that technically we didn't have a quorum for that, so we just met as a committee as the whole. So if the board could just, in their motion, it's to accept the notes that were taken.
Okay, as Herb said, we're accepting it because it wasn't a quorum, so it was the result of the notes taken at that meeting, as opposed to formal minutes. A motion to approve as such.
I'll do that.
Mike, second. Tyler, all in favor? Aye. The next issue on the agenda is the application to agree to reconsider the action taken at our previous meeting regarding the Penny Lane Comprehensive Permit Major Land Development. We have been informed that due to the nature of the law for the comprehensive permits, the condition that we placed upon the Penny Lane development, which was based on the zoning acreage, is in fact not allowed within the comprehensive permit. And so as a consequence, we don't have the power to affect that, to reduce the size of the number of units on that in that proposed development. And the possibility, essentially what would happen would be that this would go to court, we would lose. And it would cost the town a significant amount of money and time and effort. It would cause the developer a good deal of time and money and effort. And it would also potentially result in an even larger development, because the comprehensive permit as written, in fact, allows for an even higher density than the applicant was looking for. So this is information that came to us after our meeting, and unfortunately, but you know, there it is. And so what we're asking now is simply for the board to reconsider the previous approval with conditions, and that would take place at either a special meeting or at our February meeting. We'll be working that out. But what I would like to do is ask Ben, who is our town solicitor, to explain the situation a bit more. This is not, by the way, a hearing. We're not going to be taking comment. This is an explanation of an action that we would take in the future.
Thank you, Mr. Chair. First of all, I think that member Maderas has to recuse herself because of a conflict. So, yes, please. Board members, the applicant Penny Lane Development at 581 Charles Street has filed a request via petition asking the board to reconsider the January 3rd decision with conditions, specifically and limited to the condition restricting or reducing the number of units from 40 units to 25. The petition, as we all have got a copy of it, lays out the legal framework allowing you to reconsider the condition and also the arguments that the condition to reduce the number of units to 25 makes the project, in their position, infeasible, financially impossible. You have the legal authority to reconsider this. However, it's completely discretionary, and that's up to you to decide whether or not you want to reconsider. I want to make it very clear, this is not a rehearing of the application. It is strictly reconsideration. Today is not a public hearing. A special meeting is not a public hearing. There'll be no new application. Nothing has changed in the application. There'll be no new evidence. And what the board basically has to do today is two things. The first thing, make a decision whether or not you want to reconsider this particular condition. And that's done via motion and a vote. And if the board votes to reconsider that specific condition of approval, act to schedule a special meeting. And I'll be more than happy to take any questions.
I know that we were talking about the difference between a special meeting within, for example, 2 weeks, or rolling this over into the February meeting.
I believe there's some financial implications in terms of grant money by the applicant. Therefore, their request is to do this as soon as possible, as soon as the board can get a quorum together to, if they want to reconsider this condition.
Our one of our members, Jim Leffers, will not be back until February 10th. But again, that's not, that doesn't preclude the possibility of us having a meeting because we still have a quorum.
Correct. 4 members is a quorum.
To the first matter, could I have a motion to agree to reconsider the decision made at the meeting on the 3rd of January?
So moved.
And a second? Okay, those in favor of moving to the action to reconsider, say aye or raise your hand. Aye. Those opposed? Okay. In terms of a special meeting, if you'll bear with me here. Well, the next meeting of the board would be the 26th. The 12th would be less than 2 weeks from today, but is that sufficient for public notice?
Yes, for public notice, yes.
I suggest the 12th.
Yes.
I'm sorry, did you have okay, does that fit within the?
Yes, it does. In terms of notice, yes. Again, it's not a public hearing, and 48 hours is required.
Okay, and one of the reasons that a special hearing would be helpful to the board as well, just so you know, is that we have a number of applications that we anticipate would be coming in at that February meeting as well. So in consultation with, Mr. Durfee, we've determined that, this is probably the best course of action for the board as well in terms of,
Could I ask the solicitor one question? Will there be a notice to the public other than the newspaper? Will the abutters be notified?
The abutters will not be directly notified. It'll be because it's not a public hearing. Just a general notice, Secretary of State, the website, and other public locations as normal.
Thank you.
You're welcome.
okay, so,
Can I just one more
sure,
question for you?
absolutely.
So just so I fully understand, so the purpose from our standpoint for that meeting would be simply to deliberate which way we want to go on that vote and consider.
Correct. I would actually take the approach, if you can rewind the whole application, you go back to after we closed the public hearing and where we went back to the board approved the application, so that can be changed. But put the condition on it that the units be reduced from 40 to 25. That is the only part that shall be considered.
So I guess how can we have approved 30 and that be counting as approval for more than 30?
Can you ask that, see that one time?
I'm saying if we're saying that we approve the application conditioned, then we have a specific towards that approval of 30 or whatever the number was. Did we
25.
25, whatever it was, yeah, I'm sorry. How, I'm just so I understand, and I want the public to understand the dilemma that we're in, how that constitutes an approval, but not approval specific to what was approved.
Sure. So generally speaking, the application was approved. There was testimony, there was deliberation in terms of.
and based on also the conditions imposed by the technical review committee. as well.
Correct, correct. So all that in place is the overall approval of it. However, the board felt that at that point, without getting into too much back and forth here about, the facts, that it was appropriate to put a condition reducing it from 40 to 25. However, as the petition lays out some of the legal arguments and some of the arguments that say, hold on a second here, our position is that this condition will make the whole project impossible. And Rhode Island general law basically prohibits a condition that makes the project infeasible, particularly for a nonprofit organization.
So what would the motions be at the next meeting? One to void the existing motion, and then one to substitute
I
another
will provide
motion?
guidance at the next hearing in terms of specifically what your options are in
Thank you.
terms of making a decision.
Any other questions, concerns? Okay, can we do this a little earlier, like at 6 o'clock? Would that work for you, Herb?
Do it at 9 a.m. Yeah, no, I will be, whatever you guys schedule it to me, I'll make my schedule for you.
Would 5:30 work for folks even?
This is on the
Well,
12th.
12. Okay, so like a motion to have the Penny Lane decision reconsideration meeting take place at 5:30 on Monday, February 12th.
so moved.
Second,
Yeah.
Tyler, all in favor?
Aye.
Okay. And the next matter on the agenda is the comprehensive plan. Allison, you're on. By the way, excellent job, Allison, on this, this draft. Yeah, yeah. I mean, it's been a long trip and it's been excellent. It's interesting to reread this stuff after
Mhm.
so many months. Has it been a couple of years? Yeah, to finally see it pulling it together and the interrelationship between the points. I know that some of the folks who have read it and have commented on it because it is on the website have said, well, there seems to be quite a bit of overlap. And I said, well, that's intentional so that one point is not made and then, you move away from it because there's this interlocking relationship between natural resources, for instance, and resiliency and development. I mean, all those things play against each other. So it's been really great to have you working with us. So, enough of the praise, on with the show.
So, yeah, like you mentioned, the introduction and some of those other pages that have been drafted a while ago, wanted you to see that again, just to see, as time has passed, if any, edits to those, just want to give you a chance to review those again before this gets, moved along to the town council, so.
A couple of things at the very beginning. It says the acknowledgements, the town manager,
Yeah.
Kate's no longer here.
Mhm.
So,
Yeah, and I know you just lost a couple planning board members and, yeah, totally. the
Yeah,
planning
so
board
we can
people,
just
I
make-
mean, sometimes because some people were involved in drafting or involved, like. you can-
yeah, I'd like her to be acknowledged
Yeah,
for
exactly
sure, but
right.
just not as the town manager.
Yeah.
Could it be possible if we say what, in the drafting process for Kate?
Well, she was part of the planning. She was the town planner as well when we were.
Well,
working.
she reviewed and commented on some of the draft elements and provided.
So I was just trying to give her some props here. I mean,
Yeah, right. I mean, I agree. I mean, even Bob and Kate together were very instrumental in getting the thing going a lot, so. it's-
Well, that's a
it's-
good point.
it's
I mean, I
hard to-
think Bob's name should also appear in, his work on market to Metacom and, climate.
Yeah.
Resiliency was really key.
so even if you said former town manager and former planner.
Yeah.
Right, I've done this in the past, yeah, with other, the bottom, lists, others that have contributed to the plan and in drafting.
Great. The forward, I don't,
I just caught in there was mentioned that where I did a strikeout here, it referenced an appendix, but I think that was originally, we were putting a lot of, background information in appendices, but I ended up incorporating them into the kind of meat of the element instead. So
Yeah.
I just wanted to show you that change there.
yep.
So page 7 is comprehensive plan elements, market to Metacom.
And before we go there, I want to stay on the.
Yeah.
I want to stay on this on a logical
Okay,
manner. So the forward we're okay with, and there is that strikeout, which makes sense because the appendix isn't necessary for that. In the table of contents, there's the appendices, Recreation and Parks Master Plan 2018, Town of Warren Trends and Housing Report. Why are those yellow?
So, just, yeah, you'll notice some highlights here, just things I want to, that aren't finalized, so within the document, when there's references to appendices, I just wanna, at the end, make sure I have the right, like, the number, well, letter in this case, and go back and find the table of contents. Those are the two that are having reference. There might be a few others, but I just wanted to make sure I finalize that.
Yeah,
Correctly, and to also see if there are other documents that there might be some question marks as to what you want to include as an appendix in the plan, so harbor management.
Yeah, the harbor
plan,
management
sometimes
plan
that's
is-
included, I don't know about hazard mitigation plan, but, so that's something that's up to the community. We certainly reference them throughout, so we have it, the harbor management plan, hazard mitigation plan is referenced in the natural hazards, and it's incorporated by reference, the language in there.
Well, one question I would have was something like that, like the plan, referencing a document that might be revised or updated more frequently than this might not necessarily be good to include the full document, but rather include the reference so that
Yeah.
you can actually go back and look at the more current version of it, I guess, if that's what you're alluding to.
Yeah, I mean, for example, the harbor management plan is now with CRMC. And there were a number of, significant questions about claims made in it. So
Yeah,
it's, essentially it doesn't exist.
not finalized at
yeah.
this point.
I think the Recreation and Parks Master Plan was.
I thought these were important because they give, background data to support the elements, so in the housing report and the rec and park master plan, they help contribute to fulfilling the state's requirements for those elements.
Yeah.
So I think, and those aren't documents that are gonna be necessarily updated, like your hazard mitigation plan in 5 years, you're gonna have a
Right.
new one, right?
Right.
So these are something that are not a requirement
Oh,
to
right,
be
right.
updated. Those
Okay.
two documents really informed the elements, so.
And again, I think, I'd like to forward in the introduction. These are in particular, in terms of the introduction, that information is key to what the state is looking for, I'm assuming.
The introduction.
Yeah,
Really, an introduction is not required. I mean, most communities would include it, but, so this is totally, completely your discretion here.
yeah, I mean,
We
it's,
kept it kind of short, succinct,
right,
kind of trying to explain the foundation of it, the, market to Medicom.
yeah,
And then that goes along with the following table is part of that introduction.
yeah,
So,
each of those, the boxes. Any questions or concerns about those?
So, my thought here is, do we need some narrative that makes clear the relationship of the market to Medicom plan to these elements? These are goals or policies?
They're. Yeah, we haven't quite identified, they're showing explaining how the market to Medicom plan furthers the different, categories the different elements that are in the plan. So it's almost like another set of,
So it's sort of a mixture of goals and policies, or,
these are statements as to how the implementing the market to Medicom plan furthers the goals of this comprehensive plan or supports those goals.
Yeah, so I think
A lot of
what,
these you do see in, throughout the plan later on, right?
so maybe just a little
goals
narrative
and
that would,
actions.
yeah, above it as
you know,
opposed to below.
Better, it's not fully introduced, like it's not clear. Is that what you're saying?
Yeah.
Yeah, I mean, it's just sort of what, that we
It's-
understand why it's there, but I
It's
think
just
that,
in one sentence, yeah, the following chart outlines how the bold vision illustrated within the market to
Yeah.
Medicom plan interrelates with the required elements of a local comprehensive plan that supports the goals listed within Resilient Warren. That's the sentence right above it there.
Yeah, you could, almost you could even pull that down.
Yeah, I would make that
Right
its
above
own
the chart,
paragraph,
yeah.
and then maybe we can just add a couple sentences in there.
Add,
is the market to Medicom going to be in appendices?
point, yeah.
Probably should be,
Yeah, make that, yeah, the full thing, okay.
yeah.
We talk about it so much.
okay, natural hazard, and thank you, Mike, that's, that is important, because, this is where we start. We understand why it's there,
Right.
but, the folks who haven't sweated blood over it. Natural hazards and climate change, the goals. Again, I don't think we need to go over each one of these line by line.
Yeah,
Um,
so a lot, right, because you've already
Yeah, we've spent a,
The state had reviewed this, you know, so, I can just go through what I've changed from when you've seen it,
is there, okay,
For
let,
example, like the format here, again. The state's flexible, it's up to the town on how you format, but you have your goals in the element and your policies and implementation actions. Before, when you used to look at the table, you also had your time frame, responsible party, and that priority, like designation. What I did was pull those columns out and put them in the standalone implementation plan.
Mm.
That's where it's really required. So you don't have it in two sections. So, it's all that content that you've seen, it's been adjusted in here. You know, so now you can really just focus on your policy and your action, and then if you need more details, you go to the implementation program, at the end. I don't know how, again, I can put them back in here, but.
no, I actually, I mean, again, I'm speaking just for myself. I like this because before it was, it's so many words
Yeah.
and it's almost overwhelming. It's still a lot of, I mean, still a lot
Yeah,
to take in. And I think, but we may want to indicate at the beginning of each of these sections that the the time frame and the responsibilities are to be
Okay.
found
sure.
somewhere else.
So actually, can I raise an issue? It was a little awkward for me to see the sort of, let's take this as an example, natural resources and climate. And then we have the first page is the goals and the policies. Wouldn't it be better to do the introduction before each one of these sections? I mean, you know,
Yeah.
so that gives these people context for what's going to come.
Well, that was, yeah, I mean, I hear what you're saying. Again, it's the narrative introduction.
Yeah, that's what I mean.
But this is, that introduction is to market to Metacom, right, on page 11.
Well, it's an introduction to the whole, to this whole section, isn't it?
You can also move policies and actions to the end of the element, completely,
Yeah, I mean, again, that, I'm okay with that, but Mike's point is, can we have a prose introduction? You know, so that people understand what this is,
What's coming?
what it's relating to.
for politicals or just for the policy.
Yeah, before the policy, well, actually,
I would go back up to your introduction or what have you, and basically just have between the introduction and where you start into the plan is to have a section that says how to, you know, directs the reader about what's about to come.
Yeah, that's,
And so maybe you have a little text that talks about each of the elements, and that in particular elements, you're going to see the goals and the policies and that sort of thing. So it just gives the reader direction in terms of what's about to happen. Is that
Executive summary.
not even an executive summary, but just I understand what you're saying, but just it's literally an outline of how the reader should absorb the
How it
plan, or
works.
how it's going to be, how it's formatted.
and you can pick and choose from the existing narratives, how you want to do
Right, if
that.
there's if there's something special about a particular chapter because it's written somewhat a little bit differently than the others, you can highlight that. But they-
only a couple of sentences.
yeah, that's what I'm just
You
saying.
know, we're not talking about, or.
No, it should be no more than a page.
Right.
Right, I know what
Where?
you're saying, so.
At
even
the-
just
at
Right
the
up at the
beginning.
beginning of the document, essentially.
right,
Yeah,
right.
and
Right
it's
after
really
section.
directing the reader as to what's coming. And it's you've seen it sometimes where, you know, this happens frequently in textbooks.
So would it be an introduction preceding the introduction, or it would be a post-introduction?
Well, just
introduction?
somewhere up in the beginning. I
just-
don't care if
yeah,
it's
yeah, right.
before, you know, as
Yeah, I
part of
didn't
the
know that.
preface or something, but somewhere up
Right,
there
right.
that gives the reader direction or
No, I think that's great.
understanding of how the plan is comprised.
Yeah, that sounds good.
And then that would also speak to the timeline and the responsibilities, you know, if we decided, I mean, I think I personally would like to see them appear after the policies and implementation actions, because I think if you have to go, page through it or scroll through it, you could lose the person and so, immediately under it.
Explain that again. Where do you
The
want-
time frame
Yeah.
and responsibility after the, all of the, policy and
So put it
implementation
back
action.
in, like in the table.
Yeah, but not side to the side of it, below it, or,
Oh, referencing, you mean?
yeah, I mean,
Not listing each responsible party for each element, I mean, not listing each
So I
responsible
thought
party
you-
for each action, or say, or referring people to the implementation program.
Hmm.
Below it, meaning
well, following it.
the each implementation action,
She
The-
said, he said,
sorry.
he,
Go ahead.
she said, he said, sorry.
What I think Fred is trying to say is take the implementation section and break it up so that each part of the implementation action is embedded as applicable to its appropriate element. And then basically you can get rid of the implementation section, but have it the way that you set it up, like I have it up here, and put it below the other thing. So he's trying to encapsulize the goals, policies, and implementation all in one element.
The implementation program is the required element, the
Correct.
comprehensive
Yeah.
plan has to be a standalone element. Yeah.
The implementation section can be wrought throughout the particular elements. And
you sure?
and each of those sections, they may say you need to do something. Well, if they want to have something, give it to them in an email that says, here's what it is, but we've broken the implementation section up such that it's respective to each element. Now, if there are things that are in there that aren't relatable to a respective element, then that would be, something at the tail end that would say, and, this is additional implementation information, but I mean, I see where you're going, and it's just a function of the planning board and how they wish to swallow the composition of the thing. So basically the way Allison has laid it out is according to the way the statute kind of lays things out, which is to have a separate element called an implementation program.
Yeah, and
you
again,
have-
I'm not,
you
I'm
have
not,
that separate and apart. What is suggested is you're still taking that overall element, but you're breaking it apart and attributing it to the respective elements above.
I mean, what I had in mind, and maybe I thought was like, what Herb's got up there is the implementation action, but we don't see the policy there. Up, on the
Okay.
screen there.
Yeah,
And what you're doing is putting policy and implementation action and then separating out the last three parts and putting those. I'm essentially looking for where is the best location for those. So if somebody is reading this and they're saying, for example, let's just take the top one. Create a voluntary buyout strategy in danger of repetitive flooding and storm damage, which is proactively addressing the future and inundation. People would look at that and say, okay, well, that's good. And here are all of the actions. Now, when do they plan on doing that? Who's going to do it? And what's our priority? And where do they have to go to get that?
I mean, we can refer them to implementation program, I really encourage it separate, I don't know if the state would approve it without. it
Well, we could
being
do it both
standalone.
places, couldn't we?
You can have, yes, you can have it in both places, but,
Yeah, I mean, I don't want to make your job more
Because-
difficult, and I also don't want to go
Yeah.
again, make it more complicated for the state,
the
Well-
standalone implementation program, having it all in one spot, I think is helpful. You can sort it different, like whatever way you like. We can put the policies back into that part, but, and it has like that introductory statement, with the implementation program that explains, because there are some things that need to be, explained there. So if there's no standalone implementation program, like where do you put when, like there's
Well,
I agree with Allison in that
Yeah.
the thing that we ultimately want to do is make it easy for the state.
Mhm.
I don't want to
Right.
I don't want to babysit them, but on the same token, if they're used to getting the implementation section as a separate element, let's give it to
that's
them
cool.
as a separate element.
Yeah, for sure.
And then if we, if we find up at the council level that they're having a struggle dealing with it being separated or whatever, well, then we can reconsider it at that level. But I think, and what, Alice and I would say the same thing at the council level if they raise the issue. It can go in there, but for the sake of a bunch of extra pages saying the same thing, I don't think you want to do that.
And
No.
you could put, I mean, couldn't you put either a note on each one of these things or just at the, after where it says implementation action, you could put like C attached.
Yeah.
C,
It's a cross-reference.
11.
Yeah, yeah, I mean, that's,
It's a good idea.
The detail, that way they can know, oh, they would want to see the details.
I
They
think,
can
yeah,
just-
I don't think most people are gonna come for it, who, like, what office of town hall is gonna be working on that, unless
Right.
you're involved, like, I would say putting that statement, you're saying, for first implementation program for responsible party and timeframe, like, just sentence with each of the policy tables. and
Yeah.
each of the elements.
Yeah.
I think that would be clear enough.
okay.
And then it gives you the, I mean, this is the important part of the plan, and it gives you the opportunity to, present it in a different way and sort it differently, so you have it here. It's one, now all your actions, which there are almost nearly 200, you can sort them by, timeframe or by priority, so they can be presented whatever your preference.
So talking to that, it seems to me that the best thing to do is essentially follow the table of contents so that the natural hazard and climate change policies come first and that have the appropriate code. I mean, I couldn't quite figure out the coding. It says A something, but they're all listed as P something in the documents.
They're all, A is action, so, P policy, A action, G goal, that was just the naming convention I came up with, but we can,
But they're listed by P and then a number in the thing. And
yes.
my thought is we follow the same outline there, that the natural hazard and climate change is first and historic and cultural resources is second. And maybe there's a little divider between them to,
In the implementation program, you wanna keep them as within their elements.
yes, that's what I would do.
We can do that. I can
Okay,
sort
yeah,
it
that
by
makes sense.
Priority, time frames, like I did like a sort and a sort, so there.
Well, but we don't have to make it more complicated than it is. I know that's,
Yeah, so keep it within. So in the implementation program, we'll have a header for each of the elements, for all the actions are just gonna be listed. And then I can sort within each action by, priority and then timeframe.
Yeah,
Like that would be easier, I think it'd be clear, otherwise it's just a big long list of 200 actions.
Yeah.
So overwhelming. Herb is nodding, so, okay, I'll go back to, yeah, that'd be, just sort that.
okay. So that's a formatting issue, essentially, and I don't hear anybody objecting to it, so let's go for it. You want to go back to your approach, Allison, any of the things that you've changed or,
Yeah,
Mr. Chairman, if I can just interrupt, just so to put context to where I'm trying to drive you tonight, and that is I'd love to, if you are, ultimately what I'm trying to do is get you comfortable with the text of the overall plan and the maps that have been done so far, enough to start to get it up to the council level.
Yeah.
The idea being to have a joint meeting between you and the council to make sure that you're both entities are on the same page, so that if they're not on the same page, I want it coming back here to get fixed rather than at the council level. I don't think they have the time and all the agenda items that they have to get into gory detail. So if there are problems that they're going to have at your joint meeting, I want to be able to, I don't want to, but it would come back here,
Yeah.
fix those changes and then get it back to them. But the idea is to get it out of these hands and into the council hands so we can get into the public hearing
Right.
process.
And I think that what we're talking about here and Mike's suggestions are aimed at making it as clear to those folks as possible, you know, and that
I
would be the goal.
I just wanted to mention that just so
Right.
that I've talked to you about it, but I haven't mentioned it to other board members. So that, I mean, that's my agenda, is to get it out of your hands and into the council hands. And Allison is going to follow it through.
Great. So we're, so, yeah, absolutely.
Change to each of the elements was there have been, you know, we've had minimal comments from the state on required changes, but one was in regard to the state guide plan elements that they wanted, each of our elements to reference the relevant state guide plan.
Oh, okay.
elements, and even go further than that, as I was looking at those comments, in some cases, they were saying how they wanted to be like us, literally like explain how we're consistent, with how our plan furthers the state guide plan, goals of the state plan. So I inserted, gone through most of the elements now, I have a few remaining to insert the relevant state guide plan, kind of review that, go through, find the goals, policies, and then go through our plan and call out specific examples of how, you know, so that's something you haven't seen, but, so at the end of each section where we reference the, you know, supporting the reports or online resources at the end, supporting documents and online resources.
For example, what page?
14,
That pages,
page 14.
would that be the natural hazard plan?
Yeah, the state guide plan, there it is.
So for state guide plan, Ocean State Outdoors is referenced. And I called out that the implementation action to create Marshall Park directly supports the stated goal to strengthen, expand, and promote the statewide recreation network while protecting natural cultural resources as well as adapting to a changing environment.
Wow. Yeah,
Uh,
Jeez. A lot of work for you.
That one's pretty brief, some of the others, so, and then the next, actually, just below it, water quality 2035.
Yeah.
State guide plan. So, low our plan calls for, low impact development, green infrastructure strategies, similar to what the state plan supports for long-term stormwater management. How we categorize those actions as top priorities, specific green infrastructure. So I'm including that in every element to hopefully satisfy that requirement. I'll tell you that hasn't been, you know, there's a new, depending on the staff that reviews it at the state, that's something I've never included or been required to do another community comp plan. So it's just maybe
It's a new thing.
staff interpreting.
Yeah.
What's required.
That's a lot of extra work.
I know, you know, I mean, it's kind of like, you know,
Yeah.
you figure it out.
And
Not
there's
you,
so
I'm
much,
talking
I
about
mean,
the
it's,
state, you know.
General
Jesus.
rule, so much of that text is those plans that really there's so much, you could write 100 pages on how it
Right,
is consistent.
Right. yeah, I mean, and there's a lot of information in there, so you don't want to just repeat it for the sake of, but I think you did a good job in terms of,
Trying to
Yeah,
fulfill that
to-
requirement, take it too far. Take
Right,
out the
exactly.
time.
Okay,
Historic, shouldn't be anything new with any of that.
those should be, any of the changes that you made or would be marked in red or yellow? Would that, yeah.
Hit up housing. That piece. State guide plan for historic is listed here and described. I've listed specific policies that are consistent. with their historic plan.
I would say on page 24, local historical and cultural resources preservation partners.
Yeah.
I would say local groups play an important role. Huge role seems a little over the top in terms of,
Right, yeah.
And one editorial change, and I've noted it here, Allison,
Yeah.
huge.
the Warren Land Conservation Trust changed its name. It's now the Warren Land Trust.
Okay,
So you could just do a, replace.
okay, great. So lots of nice specific questions, I guess I would go to housing, let's. Again, the only change we did go state. guide.
Have you moved on to housing?
What page did you say?
Well, we went through natural resources, nothing there, or?
Do you have anything? So for housing, that was the last one that we had met on and. Just showed in red, those are some new action items.
What page is that?
Page 48.
48, yes.
Those were some comments incorporated from your last meeting on housing, so. I did show them in red since we were meeting on the full plan, just so you could see. What that might look like if you had another chance to, review it and see if you had any changes to that.
Yeah, I had one concern about that. Draft an accessory dwelling unit ordinance with
Yeah.
incentives for the creation of low and moderate income housing units. That accessory dwelling unit. Or that's a hot button. Essentially it's turning a garage into an apartment,
Well, I mean,
It's by right,
Well,
it's by right now.
this at least creates some parameters that we choose or try. That's what the purpose of it being included in here, right?
Don't even know why we have a
Hopefully,
plan anymore.
I
Essentially,
didn't
you
think
can do
that, I
whatever you
didn't
want.
think it was a blanket.
Wasting our time.
Well,
For-
there's some circumstances, for example, if you have an R20 zone, that's by right. So if you got a garage and you're gonna convert it, you're gonna do it.
Could we modify this to say in conformance with state law?
I am referring to state law.
Yeah, but for example, there are places that have limitation in terms of services or water, sewer.
They still have to get the appropriate on-site septic or connection with the sewer and all that sort of stuff. But basically speaking, you can't basically say no or put a condition on something that says, you can't do this. Yes, they have to get the connection and all that sort of stuff, but you can't use that as a way to deny an ADU.
When did that pass? This is the,
Yeah.
Two Julys ago.
Right.
I anticipate there's more being introduced this session
Yes.
already related to ADUs, so I anticipate.
what more could they do?
Well, they need to tighten it up actually, because it's so, right now, it's so open.
Yeah.
That, it basically, it's not just something with regard to low and moderate or elderly housing. It's opening up the entire door for anybody to do anything.
Right. Which is insane, but in line with the rest of this bullshit that we're dealing with the comprehensive permits.
Just remember, we're live, Mr. Chairman.
So.
That's okay. I mean, this is just, that's absurd, the well-intended with terrible consequences. I mean, who would think of doing something like that could destroy the character of a neighborhood? You need to be, we need to say, something about the fact that this is insupportable and that clearly somebody wasn't, didn't have their eye on the ball when they were putting this together. But I mean,
Yes.
that accessory dwelling unit, that could have a tremendously negative impact on an existing neighborhood and on the values of the houses. And actually the purpose being, if it's to help elderly and low-income folks, why in God's name that wasn't on the original?
So the original bill basically is trying to cater to what AARP has been advocating nationally. And they picked up on that, but they didn't put the parameters around it to keep it in that vein. So the planners across the state last year tried to get changes done to create those, make sure those parameters are in there. And that was one of the bills that was summarily ignored by the legislature last year. And this bill is actually, June Speakman takes pride of authorship on this particular bill. And we've had discussions with her in terms of trying to,
Correct the injustice.
get it to the way that it was intended to be passed. And hopefully this year they will do the tweaks. But last year they didn't, the one bill that needed to get tweaked didn't get tweaked, and that was this one. So, but that's the idea.
Well, then what would we draft in terms of an ordinance?
I think the things that need to be dealt with are that because it's essentially a use by right, which means it's just in my hands and Matt's hands, there may be development plan review type of criteria that are applicable for that. That are those things that basically say, just to make sure that you are getting if you're doing on-site septic, that you're getting your RIDEM permit. If there's, again, water, that there's capacity to handle that from that standpoint. And generally that's the way, when I've dealt with it in my previous position, that's what I basically did, was I went through the development plan review criteria for basically looking at it administratively, but assuring that they were crossing the T's and dotting the I's. But in effect, all a person has to do by law is to make an application for a zoning permit. It doesn't have to go through the planning office, say, as an administrative thing. What I used to work with on the applicants that came in the door was to at least get some kind of a plan submitted, even if it was just the on-site septic plan, something that I could make a decision on. And the purpose of the decision was more or less to help out the poor paralegal in the future that had to figure out whether there was something that was actually authorized and what does it look like. So the idea was to at least administratively have an approval that it would get recorded and some kind of a plan that would get recorded. Again, to help the paralegal and to try to close some of the loopholes on the treatment of the particular application.
They're
Mr. Chair,
also-
just to go back, I'm sorry.
Yep.
In terms of AH3, so what happened with changing the law, now they made ADUs, you can count them towards your low and moderate income housing units. That's something new also in the law, and I think that's exactly what that action is talking about.
But to create incentives for the creation? I mean, I'm
So
not sure I want to create
they can't-
incentives for
no, but I'm
this.
saying they can count toward your,
10%?
yes. It allows it to be counted toward. I think that's, again, not saying support or against them, just saying that's
Right.
possibly where that came from in
Yeah,
terms
you
of.
get, right, it's like a half, a 0.5.
Correct. And that's new in the law, that now allows you to count these ADUs towards that.
I'll just give you an example, so local ordinance,
Yeah, right.
you know, I think having that in place to control, you can
Just take out the
give some direction
sentence.
here, like the size, what is the maximum size of an accessory dwelling unit, for example, that can be.
Okay, yeah, well,
established, the
what I'm
number of
saying is
bedrooms.
the incentives is not a word I want in there. I mean, we're not incentivizing people to turn their garages into freaking dwellings and,
Why not? People move their parents into their basements and their garages and above their garages all the time.
because if it, you know, but they do it illegally.
So
And
what I-
in some
They don't.
cases, you don't wanna have it. So is there any, I'm assuming at this point, there's no control
Back here?
over, wait a minute, Ashley. I'm assuming that at this point, there's no control over somebody saying this is gonna be an Airbnb, this
Oh,
accessory.
actually, you know,
Yeah.
we presented the town with our legal opinion in that the law before was considered in-law apartment. So it technically had to be an in-law that lived there, and you had to once a year register who's living there. So when the law was changed, they just said we couldn't restrict the familial relationship. We took the strict interpretation saying, hold on a second, it can be anybody, but it has to be family still.
It has to be family.
It has to be family.
Yeah, I mean.
You can't say it has to be in-law, it can be a nephew, it can be et cetera, but again, that's a strict interpretation of the law, by the exact language of it. So that's right now what we have in place, and when somebody comes, they do have that regulation, it has to be for a family member. We can't restrict who, but it has to be on a yearly basis, come through the process and say, this is who's living in my ADU.
Right, so,
Yeah.
I mean.
Right now, that's-
As Ashley said, if somebody wants to move their parents into their ADU, that's one thing, but they can't use it as an Airbnb.
Correct.
Well,
Correct.
Or-
having an ordinance, again,
have a
to
short-term
protect the town.
ordinance,
So
yeah.
if you had an ordinance, it
Yeah.
could spell that out in the ordinance.
All right,
But
again,
we
that's,
are
so let's take out incentives and ordinance to protect the town and to meet.
And the reason I added this in was partly, your housing element has your housing plan to meet the low and moderate income housing requirement, right, your 10% goal. So this is one of the strategies that is listed. I was trying to come up with strategies to get to your 10%. So having some of those ADUs that are created, if they are to be potentially restricted to low and moderate income housing and meet that criteria for being on the low and moderate income housing chart, then they could contribute to your 10%. Otherwise, you know, by striking that, and we can change the word incentive, but I guess you're right now that it doesn't need to be deed restricted or any, and it could just be that 0.5 for each housing unit, ADU. So it doesn't have to be one of the strategies, but again, I was just gonna try to come up with.
Well, I mean, I'd like it to have a protection. You know, it's one thing to move, you know, grandma and grandpa, and it's another to be making money off an apartment.
No, that's intent, yeah, the intent of this is to be year-round housing units. This should not be, you know.
Right, but
rent-
again,
weekly
the
rental.
intent was, I think, initially to make it for low and moderate income, and the law was passed without that being explicit, correct?
It just says now that it's eligible for the count towards your 10%.
I think they're just creating housing units, not necessarily, you know,
Correct.
they're wanting to encourage diversification of the housing stock and creation of housing units in general, not just low and moderate income housing units with that, you know, the ADU, but ADU
So
having
maybe
an
it's
ordinance,
just-
You can restrict it, you can require, you know, an affidavit be signed by the property owner that it's going to be leased yearly, you can, you have, you know, you can have staff check on.
Yeah, no, I
That
mean, that's what I would, I mean, that's,
Um,
We
things
currently
like
have that in
these.
place, actually.
okay.
So we have the in-law apartment ordinance, which pieces of it avoid. Other pieces we still use, including that restriction on a yearly basis.
So
Yeah.
should we say revise our accessory dwelling unit?
I think you can
Ordinances?
just say something like assure, you know, our ordinances enable accessory dwelling units for low and moderate income housing.
Or
But
is it
I-
just low and moderate?
I'm still thinking that we're talking about family relations though, right?
Why?
No, I think, so I think.
Well, that's
what's
what
happening-
Bennett said.
Yeah, correct. So.
So I think
Two different things
what's
here.
happening
But
is that.
no,
there's
I don't
that
think
law-
the law doesn't do
Right.
that. The law allows
That's not
anybody
entirely-
under the
Right, so
sun
I
to do
think
that.
that what
So
he's
what I'm
saying-
getting at is that the law unhinged the related by blood or marriage, and it unhinged the need to have a joint doorway or entryway for the particular unit. So basically what can happen under law now is that does not have to be related by blood or marriage and can have its own separate entrance. So, and the reason for that as a good example for what they're trying to promote and what AARP is trying to do is, for instance, is somebody may want to stay in their house, but have an accessory unit where it might be a caretaker, whether it be a family member or not, from that standpoint. And also, it can be the reverse, that the house is too big for the person at this point, but they want to stay in the area, so they might want to either have their family move into the larger house and that they move into the accessory unit for the term of their life, or even vice versa, that there's someone that would move in there that would help them as they age in place into the accessory unit. So the idea was to create things open enough to allow for different forms of affordable housing that accommodated those that owned the particular property. But I think what happened in the legislation was they opened up the doors, but didn't put the qualifiers in there with regard to that, because basically what can happen right now is that anybody can build an accessory unit, anybody can live there, regardless of income, regardless of anything else.
Well, I
So
see
we
Ben-
June
but-
open-
but I see Ben
So,
checking his head.
we're talking intent, possibly. We're talking legal interpretation until they
Clarify it.
clarify it. As of right now, when somebody comes to zoning board for a ADU, we still require that because the law just states we cannot restrict familial relationship. We basically saying, hold on a second, that just means I can't say it's gonna be for my in-laws. It can be for a distant cousin. It's a strict interpretation and I will.
But it limits.
However, but I think the intent is what the planner is kind of discussing, it. That's probably which way it's going to go once it gets clarified. So I would kind of,
It sounds like, I mean, let's just, to get back to the comp plan, I know not to debate all this, the state law and the ADU, it sounds like already your local zoning has some in-law zoning section and some of it's not consistent with state law, like he said, need to be voided. So one action item is to draft an accessory dwelling unit that's consistent with state law, update your in-law sections to be consistent with state law, you know, by creating an ADU, enabling the ADU, and I think that sounds like a necessary action, and that's.
But
Yeah.
the language that you had in here was simply in regards to that, make sure that we capitalize on whatever benefits
So
come
I'll
from the
strike with
housing.
incentives for the creation of low and moderate income housing units, and it's not that that can't happen when you're drafting it, right? I mean, you can certainly include that, but if that's cause of concern right now, we'll take that language out, just say, you know, update the in-law section of zoning ordinance, draft accessory dwelling unit ordinance consistent with state law. We'll see what the state does this year. So we don't know exactly what that is gonna look like, so you'll wait till the legislative session's completed.
And the town does have, if you're not aware, they do have a short-term rental ordinance. So people
Yeah.
that do have those things do have to register that. So the council and the solicitor have worked to try to, close up some of the loophole from what was passed with the ADU law.
Right, I think that, and Rick can correct me, but I think Rick's thoughts on this were that in the context of this reading right here, it almost seems like you're instructing someone who reads this that we want to push towards the establishment of these types of housings, affordable housing on everybody's property, like it sort of reads like that, which I understand in the context of what you're saying, but that's not, you're trying to say, if we're gonna have this thing that already exists, we need to make sure we have this, the ability to use it in a much more beneficial fashion like this.
The context of the context of the legislative purpose is to allow ADUs as a right.
Right.
Essentially. What I think is fair for the town of Warren to be able to do is to ensure that if that's happening, that at least we're retaining the flavor of what we want to have in this area, and are there measures of somewhat limitations that we want to have on that while still trying to promote affordable housing and get closer to the 10% from that state.
So is June open to the modifications you're talking about?
I believe so. In my opinion, she's open to hearing, with regard to that, to the bill that she is, takes good pride of authorship in as getting it to the way that it was intended to.
So
to do.
as the sponsor of that legislation,
Mhm.
presumably the speaker and the Senate president would defer to her, probably.
I would never commit to that.
But, I mean, you see my point.
Concept, yes, I do think that at least in terms of that bill and her having it close to her vest pocket, I would think that the speaker would be wise, as well as other individuals, to consult with her as to any changes that might be warranted.
Thank you.
Okay, so again, I just think we take out incentives and talk about bringing our ordinance in line with what the state offers, but not, I mean, because quite frankly, I think if we're gonna make low and moderate income housing, make that 10%, and I know that Tony fought for this, the fact that we have a lot of apartments already in this town that should qualify for affordable low-income housing. And, again, the legislature and its lack of wisdom is unwilling to count things that don't fit within this narrow tunnel vision of what constitutes affordable and housing. And I mean, we don't want to have our comprehensive plan paying lip service to a poorly constructed law that essentially penalizes our town by force and, turns us into a rubber stamp. Which is how I'm sort of feeling today after our most recent decision. So anyway, let's move along.
Page 52, I've highlighted a couple sentences in regards to this language was trying to provide a status of common permit projects.
Could I think, my thought here is that it'll take us a couple of weeks to get this done. Could we mention Liberty Street and Penny Lane? I mean, I know they're not finalized yet, but Liberty Street is approved. And Penny Lane, in all probability, as of the 12th will be.
So
I don't think we can say that.
Yeah.
I mean, they're in process right now. So,
that's why I just want to be careful. I highlighted,
yeah, we can't, they're not done. We're-
so
Okay,
they're under review is how it's worded
not right.
here. I'll take your guidance and Friday, maybe legal guidance here, whether or not this should even be in here. What we're trying to show is how many units we anticipate coming online, right, on the low mod chart. So trying to come up with that best guesstimate of how many units might be created in the next 10 years. As you see that comes further down in the housing element, trying to put numbers for strategies. So
Where are you?
anticipate, so this again, have been drafted a few months ago, but 2 comprehensive permit projects that have been approved, an 18 unit on Metacom and a 15 unit on Main Street. It says both of those under construction. I don't know what the status is of those, if that should be updated, but.
no, they're both under construction.
Yeah.
One's finished, the one on Metacom is done,
Yeah,
and the 15 unit on Main Street is limping along.
yeah,
Okay.
that's
Well, I just
another,
wanted to- Here's like where it could become dated, where I just wanted to put the correct status.
How many units have been done?
I don't know. And it's, the insulation is flapping in the wind.
So, but under that page 52, at least you want to say that the 40 units on Penny Lane is under review, do you not?
That's up to, I don't know, do you want to include that?
I mean, I'm
For Liberty
only,
Street?
my concern there is that if it's not, I mean, we're prejudicing.
It's under
a
review.
decision.
Not listed. Not listed. We could just say several other comprehensive permits are under review, period,
Yeah,
and maybe not reference.
and by the time this is finished, we may be able to put it in.
Okay.
I mean, I completely understand what you're saying, and that gives us greater power.
Gives us some leverage, I mean.
But I think, you know, it's gonna, we're anticipating this, the comprehensive plan is probably gonna be done June.
Sure.
Yeah,
No, I'm sorry.
that's it.
Sorry for the crass answer, but I would like to be able to get this out of the planning board's hands, if not tonight, at your next meeting, with the idea of scheduling a joint meeting with the council in probably the March timeframe. And if they concur, get them to initiate the public hearing process. If they get done their stuff, say in the April-May timeframe, without too much change, we throw it off to the state. The state has what, 90 days? I think it's 90 or more. I can't remember what it is, but from my understanding, they use up the whole kit and caboodle of time. So even though you may be done and adopting it, the state formal process of review has a statutory, they have a time limit.
So it could
But it's-
conceivably go to August,
it'll-
for example.
Yeah.
It could be used for the purposes of, if the town has adopted it.
The
I
town,
think it's
the-
still, it'll become your approved comp plan,
It's-
even though it's not approved by the state yet, you can use that.
yeah,
right?
they can use
Yeah,
it, right?
yeah.
So we could use it in
Right.
terms of an argument if with,
Yeah.
okay.
Correct. But
That's- and that
but
would be
you know,
important.
caution to the wind in that if the state comes back and says you need to fix X, Y, and Z, you got to do that and then
My
re-adopt
guess
it.
is that
But
that's probably not gonna
Right,
happen.
we're trying to make sure.
Because we've gone
That's-
through
that's
this
why now-
initial.
this is
screening.
why the state likes to do the pre-review process so that that doesn't happen in the future, at least guards against it.
Any approvability concerns should. be
So what would you
addressed.
like tonight? Do you want us to approve the draft plan as submitted? So,
If you guys are comfortable with the draft as a whole in terms of its text, with the amendments that whatever you ultimately decide on, I would love it if you're comfortable to say, let's forward this to the council, with the idea of scheduling a joint meeting to discover whether both entities are on the same page to be able to move
we
forward.
do that, Fred.
Yeah, I'm hoping that happens. There was another highlighted section on page 53. We're almost there. It's 63 pages in entirety, right? You said a local growth center, was that a,
That's kind of for me to make sure that it's addressed in the land use element, so it's not. I just want to make sure it's internally consistent, that highlight is from.
that terminology or?
That's state terminology.
Local growth center.
Yeah, that's what I figured. Yeah. And then, your,
Going to the low and moderate, well, so the 10-year affordable housing action plan, that's part of the housing element.
yeah.
Here's where we identify strategies to help the town make progress towards achieving the 10% goal. So communities will put numbers, estimated number of housing units you're going to create for each of those strategies. A lot of times it's a complete guess. So I'll be honest.
Yeah.
It's how can you predict the market and, you know, an application coming in with a lot of units. So you're trying to take an educated guess here. So the top bullet item, relates to the market to Metacom plan. So in that case, we did have a plan that outlined a specific number of housing units and a percentage of those that could be low and moderate income. So I plugged in that rough estimate there. And then the comp permit applications that the town continues to see, anticipating, you know, over a 10-year period, how many units could be created because of those.
Actually, I mean, you know, if this speaks to Mike's concern before, you know, that second bullet, significant number of comprehensive permit applications in recent years. Unfortunately, of the 6 that we've received, it's only been 1 that has been, you know, fully affordable, and the others had 25%. But if we got another Penny Lane in there, that would make a huge difference in terms of, you know, those 60 units. So, I
Maybe
mean,
we ought to up that estimate. on
yeah,
the
I think
assumption-
we could make that. If we're extrapolating from, and here we're not committing to Penny Lane or to Liberty Street, but we are saying that. That comprehensive permit applications are pending and currently in the local review process, so that places it in the context of where they are. Given that, I think we could increase that to 120 units.
Of low lot, not just total units of comp, like not just the,
Yeah,
Could be expected to be developed and added to the town's low and moderate income. I mean, that's the kind of thing we could incentivize if we could direct them to, other locations like Metacom. Here we are talking about 70 units from that market to Metacom plan. That's actually would be a fantastic place to drop a Penny Lane style development. That was originally designed with, this kind of mixed use, commercial, retail, housing. But, that may or may not happen. That could also be an area that would be more dedicated to.
actually, if you remember, the neighbor's point was, why don't you do it on Medicom?
Well, yeah,
That's not-
I mean, that's, that. But anyway, I'd like to up that 60 units, given the stuff that's in the pipeline to, if you're talking about a 10-year period, still seems low.
so you think that could be bumped up,
Yeah, because we're talking about, we need 330.
right? So,
Like,
But you're likely gonna get Settlers Green back in the door, so.
yeah, but that's
25% of
25%,
120.
isn't it?
Yeah, but 25% of 120 units.
Boy, I hope that, okay, that's a whole nother ball of wax.
And 75 Crowd walk back in the door, so that's 3 units out of the 12. And there's another development that I'm aware of, but not public yet.
Right,
Mhm.
okay, well, anyway,
the
that's,
next one is adaptive reuse, that was part of, the last legislative session. The state is requiring, adaptive reuse projects. I know you've already talked about this with her, so there'll probably be an ordinance adopted this year, right, on that?
Yes.
now so that's what we're talking about, like something like Croad Street, which is in an industrial area, or,
So if a building previously used as, commercial could
Yeah.
include housing units, or it could be adaptive reuse, like the school, anything that was
Anything that's
use that
commercial or
wasn't
industrial
residential.
today
right,
could be.
Could be
converted
con-
Adaptive reuse is permitted by right.
Even if you don't allow residential in that zoning district.
right, yeah,
So, and some of those units could be low and moderate income housing, so that's why we've. essentially-
again, I would say, increase it to 40. We have enough buildings, if you look at Parker Mills or, should, just for an example, should Peter King decide to sell Parker Mills, that could easily be, not easily, but it could be turned into a significant number of apartments. So 20 seems a little light to me.
Yeah, I think that's what his, not selling it, but then his plans are to look at housing.
Yeah. And this would make it easier for him to do it, in terms of not having to go through as many hoops.
Yeah,
that he
right,
would.
right, yeah. I talked to him
So
about that.
I'd say double that to 40.
I mean, it doesn't hurt us to make these numbers higher, does it?
No, they're rough estimates anyway, so,
To be reasonable, I guess also the state might come back and say, well, are these realistic figures?
I would say, yeah. If you're looking at the amount of land that we have available and some of the places that we've got, Cutler Street and Parker Mills, those are significant sized buildings that could easily be, translated into, a low and moderate income apartments. And if, You know, particularly if you had a developer who was saying, you know, we're gonna do more than 25%, you know. Again, if the legislature in its, you know,
You can't do that. You can't, the law is 25%. It doesn't matter which development. If there's 25%, you can't say, oh, you have more, so we're gonna let you, and you don't have more. That would definitely get overturned. So you can't
Uh,
really discriminate.
no,
What are
what,
you talking about with the,
there's two things. One
anything.
is, the legislature could change this 25%, realizing that they're not really meeting their goal because it was a bad decision in the first place. The second is that a group like the CDC could come in to an area and say, we're going to do all affordable units. And as a consequence, have much less resistance from the part of the town, or not even from the part of the town,
So,
that it would go along with the law. So, you know, this is what happened at Penny Lane. That's why we're reconsidering our decision.
so what you're saying is Warren wants Section 8 project style housing.
No.
And yes,
No.
no,
yes.
it's not.
It is. When you go below 60%, it's the same funding. It's called a different name. And so when you cluster development like this, it's the same as any other housing authority. And so that's what you're saying is that we support more developments that increase. So I mean, if that's what Warren wants, you're gonna get a lot of pushback from residents because most residents don't want that. And that's where the 25% comes in, because it incorporating low to moderate income homes into existing homes is more equitable, it's more inclusive, and it doesn't target people. Whereas
Why
when you
would
do this,
50% do that?
it could as well, but it's 25% is a lot. It's not gonna change. I mean, Housing Works where June Speakman worked, has been the leader in this. They've been touting this for God knows how many years now. It's 25%, it's gonna stay. And so if you develop, it's your standard, right? You can't change the standard of the state, and it's not gonna change.
Again, I mean, you know, I'd like to think that it could, but if it can't, I mean, quite frankly, if I were a developer and I looked at this, I'd say, you know, we've got carte blanche if we do it 100%. I'm not suggesting we should have it. Actually, no, I don't. This adaptive reuse is what I was referring to and saying that we would result in a rough estimate of 20 units, package bills, but to pass during the 2023, streamline the local review process. It's on page 54.
Right.
Town's local ordinance and regulations will be amended to be consistent with state law. An adaptive reuse ordinance will be adopted in 2024 that could result in the creation of housing units, including low and moderate income housing units and buildings that are converted to that use. This could result in a rough estimate of 20 units. And I'm saying, I think we could have more. I think we could have 40 units if we could encourage developers to go beyond the 25%. Or if a community development group came in and said, we're going to do more. I'm not promoting it. I'm saying that if it's a rough estimate, why not get it up there higher? Because I'm looking for some leverage here when people come in and say, we want to build a development like, say, Settlers Green, and we can say, look, we're working toward affordable housing, but we want it in the right place. You know, that's my goal, you know, personally, that's what I see as an important goal, to be able to say, we're working toward this, but we want some ability to determine where these things go. And if we've got a strong affordable housing unit statement in here saying we anticipate a lot of these units, that should give us that strength, correct?
Yes, my thought is, I'm less, I don't like where you have the 25% in there as a requirement, part of a zoning, only because, you know, we don't know what's gonna happen in the future, and let's suppose someone comes in and, let's say like a big tract of, let's say the job lots, that whole facility is taken over by a developer who wants to do a couple of different things, and in one section, he's gonna sell. I've done a mixed use development where I sold a big chunk to a townhome developer. And so if that townhome developer is someone like the East Bay that did 100%, then the rest of the developers shouldn't be bound by 25% because the net develop, the project itself, which could be comprised of multiple developers, might have more than 25% for the whole thing, but some developers may not be doing it. Wouldn't want to have like every single developer of every portion be obligated by the 25%, I don't think.
Well, they're not, only if they come in for with
The comp permit,
comprehensive
is
permit.
only, if someone wants to do a comp permit, they're required to do the
Right.
minimum 25%.
If they want to do a straight development, they don't.
Well, I was just looking at like the first paragraph, it says, the last sentence is, if half of those units are created over the next decade and a minimum of 25% are required to be affordable. Oh, and so it's just speculating that. I mean, I don't know if this is stating that we would, part of the form-based code, we would
Yes.
require.
I think that's what it's stating. That was my understanding. I haven't, so the draft form-based code, that was going to include a requirement for affordable
the-
units.
so-
Have you looked at that recently? Well,
I thought the density bonus there was flexible. It depended on what percentage you were doing.
So I haven't looked at the form-based code recently, but under enabling legislation, you can do inclusionary zoning as part of your zoning ordinance, which requires that any development that comes in a portion of it has to be affordable. The comprehensive permit law is enabling legislation that originally was just for community development corporations and then was amended to open it up to any developers. And again, that is if you wish to do a comp permit, it has to be at least 25%. So there's a lot of communities because of that law that are either taking out their inclusionary zone law or it doesn't, it sort of is moot. Because the comp permit law allows for more housing to go in that's affordable on that basis. But keep in mind with regard to the law, the way that it's changed and now effective as of January 1, there is a right to density. So for instance, the Community Development Corporation is eligible for 10 units per acre. So and they have the right to that now. And there's a couple different thresholds from that standpoint, but them specifically. So if you look at the Penny Lane application as an example, so they're just over 4 acres, they can technically come in with more than 40 units and have the right to that. So and again, that's part of the root of the reconsideration that you're going to talk about, but these are some of the changes that are occurring, and overall the comprehensive permit law, you can have discussions till you're blue in the face with regard to your comprehensive plan and your zoning and subdivision regs and put stuff in, but the comprehensive permit gives some rights to developers to come in and do stuff. Granted, they have to ask for waivers, not variances as a for instance, but effectively whatever you kind of have in place, you have to be cognizant of the comprehensive permit process and what its purpose is doing, and it's kind of usurping, substituting in what you normally would do for the sake of affordable housing, and then the last sort of piece of that from that standpoint is besides that is that once you do get to a level where you may meet the 10% goal for your particular community, then you have a little bit more control about what you can do with your bylaws versus what the comprehensive permit gives by right to developers. But you got to get to that threshold amount first.
So the more units we get, closer to the 330.
Correct.
The
And the
better we
more
are.
value.
And that's why I'm saying,
Right.
let's increase this based on, what could conceivably be, not that we want to have it, but that it could conceivably be there and we'd be able to say no to some people.
Right,
which is
it's
what
it's still important,
ultimately we
it's
want
still
to be able to
important
do.
to put a plan together with your vision, what you want, putting
Right.
what I call the flavor of Warren into it from that standpoint. Because you still have to do reviews and regardless of whether you've met your threshold 10% or not, that to me is extremely important for a particular community. And so I agree with you, Fred, you need to, push forward on those particular things, but you also need to recognize that there's a balance between that, you know, that 10%, I don't know how the number was picked, right? But you know, regardless of whether it was arbitrary or specific, in terms of that threshold 10% is critical with regard to how you deal with stuff. The point that I always try to make is that I find it disappointing that the state doesn't just keep the 10% at the state level and doesn't apply it at the local level, because any singular affordable housing unit that's built in Rhode Island is applicable towards that 10% overall as a goal. But if there's more units being built in another community because they have more services or something nearby, great. We should all be able to take credit throughout the state for that. We shouldn't be necessarily held hostage as individual municipalities, as long as we're at individual municipalities, you know, committing ourselves to the promotion of affordable housing from that standpoint. That's why, in part, I want that housing needs analysis to, you know, I can't wait for that thing to get completed, because I do think that there's argument that's going to come out of that for us to defend ourselves in terms of saying that we do have a fair share of affordable housing in this community, whether it's deed restricted or not. You can't ignore it.
Right.
And that's part of the point that I think is a future discussion that will be had.
Affordable housing is not a bad thing when it's done well for the community that it serves. And so we know we need affordable housing for people who no longer want to live in their single family homes. So we have, if you look at the data, our older community is disproportionately low to moderate income. We are not building housing for those individuals who could use it. That needs to be done. Our workforce here, which is 80 to 120%, can't afford to live here, and our manufacturers can't find. So affordability is needed, and it's not a bad thing when it's done right and done to conform to what your town needs and what your community needs. And I think that's the biggest thing.
So how do you get it done? What can we do? Can we do anything to try to encourage?
Well, I think right now the state's taken everything out of our hands, so you just have to say yes to it. Like, we're wasting our time, essentially.
Yes.
We can't say no to anything at this point.
Penny Lane was a waste of time.
Well, I mean, writing this is a waste of time, because essentially what the state is saying that Penny Lane is on an R40. And that is our, you know, okay, so,
Which is not less.
Right.
People have brought up. But that was, you can't talk about specific projects. I
right.
think we want that in the process now.
But is there something that we could do with the zoning, ask for zoning
like
to
it.
be done to encourage,
No,
you know,
because if you have,
builders to go in like Metacom area
And-
or something?
This is what this is exactly what we're working on here. All this text here are strategies to increase the supply.
Yeah.
of affordable
Yeah,
housing.
and all I'm
So
saying is
we
let's
think about-
increase the number of potential units that we can get. I mean, again, I think Allison was being conservative, and I appreciate that, but in light of this, it seems to me, you know, like with the 60 units, just based on what we've got in the pipeline, that could be 120. That the adaptive reuse ordinance, given just, you know, in my mind, the buildings that we have that are potentially available, that could go to 40 units.
And then the
Um,
next, so the next, I have those noted, and the next comment, the next strategy is regarding infill development. We talked in the plan about the inventory that was drafted by a prior planning board member, and that being, taking a look at that inventory again, you know, prioritizing, evaluating those parcels, prioritizing those that seem, you know, there's a consensus that could be a good fit for locating affordable housing units, and then have the, you know, the town discuss with nonprofit developers or other developers creating, you know, housing units on those lots with the property owner, existing property owner,
Yeah.
right? So that's a strategy that is listed here potentially. I just plugged.
Again, I would just take out an ordinance to establish the incentives word
For the next,
for the next one,
ADUs.
yeah. I mean, the 15, you know, seems reasonable in terms of that. it's just too amorphous, those lists that, you know, were put together, all of those locations. I can't. And, you know, I've gone over that, but I can't, it's not like looking at something like Parker Mills and saying, okay, well, that has a potential. You know, these places that were identified in that study were chunks of land for the most part, you know, so it's like,
Well,
I'm gonna modify this ADU, bringing up, as we raised tonight, that now with the new state law.
Yeah.
0.5, you do get credit, it doesn't need to be. deed
yeah, and I
restricted.
think 5
So-
units, it
But-
also points out the fact that these are not gonna solve the housing crisis.
So that's like 1 unit a year, you know, we're talking, that would 5 units, is 0.5, so if you say.
the 25 unit requirement in that first paragraph, I mean, I think that is potentially problematic from if our goal is to try to incentivize developers to come, then when you have, I mean, that's great with something like, Parker Mill, and it's great with a lot of these, a lot of projects that can be there. But what it ends up doing is that if you have small tracts and you have like a 30 unit development, and the developer if he has to do 25% for any type of development, that is basically gonna limit all the development in that area to a different price point model.
Well,
Instead
no,
of
but
like
that's
trying
only
to-
for form-based code and the market to Metacom. I mean, we're not limiting developers. I mean, if, for example, you know,
I
somebody.
guess I just wanted to understand, like, is there some flexibility where you can move those 25 around into that form-based
Oh, I don't know.
thing? Like, for instance, if Peter wanted to do affordable in Parker Mill, and I've spoken to him a lot about that, and that would considerably be a lot of units. And then suddenly we would have made a much bigger chunk of the 25 for a big chunk of Metacom. Would that open the door for a developer to do a non-affordable and then another one to do affordable? You know what I mean? So that it was
It's almost like trading tax credits, you know, I don't think that the law allows that. I mean, I'd be
I should
surprised.
say,
well, it's not tax.
Building it.
No.
No, but it's like.
So what I
it's
mean is,
like-
though, it's like, if you do a mixed use development, like if you do a mixed use development, you might have a developer here at this price point, another developer here at this price point, another developer here at this price point. And the land developer would be do the site planning for all that. Well, if all those individual developers have to have a mix of 25% within each of their little sub-developments, then it just changes the whole model and it eliminates the lion's share of potential developers to come in, because you're gonna have to find developers that are gonna just do this specific property
I
type.
get
you know
your
what I mean?
point, yeah, so I think I don't think the town needs to decide this now, so for whatever you decide with your form-based code and wording of that, we don't need to decide that. I'll change this language here to say, without changing the estimate even.
Okay, perfect.
Just say, as part of the implementation of form-based code for Metacom Avenue project area, a mix of affordability levels for housing units will be required.
I even like the encourage the 25%, that's fine, this is not, it's not like
This
a
is where I.
mandated.
So
Yeah,
if half
I'm
of
okay
those
with
units
that.
are created over the next decade, an estimated 70 units. You know, I struck out a minimum of and are required to be, so over the next decade, if 25% are affordable of those units, then 70 units would be added. So it's not saying that it's required or
Yeah.
that they all have to be within every building,
Okay.
it's just
Right,
saying
right.
that.
That answers, yeah,
25%
that
of
answers your.
all
Because
those
in my
units-
mind, I had the image of that drawing that early on in the market Metacom plan was the site plan of all the Ocean State, which was almost like a center that had all these parcels. And then I can imagine, you know, there's the high-end townhomes here and then the bungalows over here. And if everybody had to be, I was thinking it'd be difficult to court developers with that confinement.
Well, I mean, I think this came from Bob's original market to Metacom plan, which
Yeah.
was based on a vision of actually one developer coming in.
Right,
and
no, I
buying.
know
So
exactly, yeah,
that was what this was predicated on.
Yeah,
And that was what the
also
form-based code was based on. So,
markets medical plan.
you know, whether that is how it
No.
plays out or not, who knows?
Okay, so I think we're down through just the last one where the strategy listed is in regard to the state law advocating for a change in affordable housing legislation. So
Yeah.
this is something that obviously has come up a lot. So I don't know if the state will allow us to use this as a strategy, changing state law to get to our 10%, but it speaks to the having the, you know, vouchers counted towards our inventory that is credited to the local.
Right on the nose. I mean, this is the, you know, and this has already been presented, my
Yeah.
understanding, by Tony to the legislature with Kate. You know, give
And
us
in fact,
credit
again,
for
I
what we've
believe
got.
It's been reintroduced this session.
Yep. So, good.
So it's on the table anyway. So I included it. I know it was important to you to have at least the narrative here. And I gave the, Kate had included those figures in back when the Water Street project, there was a table. So I plugged in about 160 units.
Yep.
Is what could be credited.
Is there a
Yeah.
way, I'm sorry, is there a way to instead so we know that there's housing units that are already should be considered, but they're not deed restricted. Is there a way to incentivize the owners of those properties to deed restriction so we can count for what we have?
Existing
Yeah.
units.
Yeah, because that's the problem. We know there's existing units.
Right, but yeah,
It's expensive on a per unit basis. And right now, their rent rate would probably be very consistent to what they're already getting, so they're,
That's what I mean. So
Yeah.
they're already doing it. So if they would just,
well, they would have to like probably do like building improvement modifications to get it to certain standards that are required. Yeah, and then they'd have to also.
need to get the
de-restrict it,
restriction, yeah. So is there a way to incentivize people to do it?
yeah, there's not really an incentive for them to do that. I mean, this is one of the questions that
backwards, yeah.
concerns, you know, you go to these folks and you say, wow, your rent is what we're looking for low and affordable. And the first thing that pops to mind is I had to raise the rents, you know?
Anecdotally, the Affordable Housing Trust, when they were trying to initiate their program with regard to getting some money out there for rehabilitation of rental units, in a good chunk of the cases of the property owners, landlords that they spoke with, a lot of the rents are less than what they could be charging for affordable rents. So and anecdotally, that, you know, is, I can't sit here and quantify it right now, but there was a fair share where people were actually doing rents that were below the market rent that making it technically affordable. Also, under the Low Moderate Income Act, there is a part of the statute that says for non-deed restricted units, you can count them towards your amount, your 10% amount at half, you know, a half unit per unit type thing. So I was just sitting here trying to do a back of the envelope calculation because, as a for instance, over 10% of Warren's population is persons of poverty by the census definition. So and I was just trying to figure out number of households and who may, based on their income, because there is some statistics that are out there. And then also I'm sure that's part of the examination that we're trying to undertake with regard to that housing needs analysis that we're in the middle of dealing with. Again, trying to show that there's a fair share of our housing units and population that meet the definition of affordable housing. And I want to figure out a way to get credit for that, because even though it's only half a unit per unit that gets the count, any half unit is going to be closer to our 10%.
Well, and certainly more than an ADU.
Correct.
So,
And
With the
this
new
was
laws, that
discussed
people just
further.
build 3 units in their backyard now and become affordable.
That's what I mean. Pretty much do anything. I'm
So
not
there
really
is
sure.
some level of calculation that the town is capable of going through and I'm sure the state has to validate it, but I think at least I think the information that we're having done with our consultant, Weston and Sampson, will help get us some of that evidence testifying to the fact that there's some units that need to be added into our overall count.
And then that discussion is also on page 51, the last paragraph there, so if you want to scope that, it speaks
Yep.
to
Wrong way.
anecdotal evidence of the rents being lower than with low moderate income housing equity part of the,
51, you said?
yeah, the last paragraph of 51 captures that discussion that the planning board has had at the meetings about, again, the state law and needing some, modifications.
Yeah, the town of Warren by including housing choice vouchers issued by the Warren Housing Authority and would bring Warren's calculation to an affordable to around 8% right now,
So-
That's
So they're not counting the housing vouchers.
No. Yeah, so,
Absurd.
yeah,
Is the top limit is targeting a specific percentage, income earning percentage, including up to 120%.
Right. Which an affordable house is, I looked it up today, it's like $400,000.
it's frightening.
Right. Yeah, here, I think an affordable house, 3-bedroom is over 400,000. It's considered affordable here.
Okay, so back to page 55, we've gone through the estimated number of units for the strategies. In the listing of, here's where you can identify basically the types of housing you're looking for, following the criteria that affordable housing should be, generally, these bulleted items here. The last one I highlighted, this was added based on the last planning board meeting that discussed the comp plan. So I highlighted it just because I just wasn't sure if this was something legally could be stated. I know this was preference that's been discussed, but now that we drafted the language, just taking another look at that language to make sure it is something that the planning board.
Maybe include
I know actually-
existing LMIH units as opposed to a high percentage,
What was that?
existing existing and future LMIH units.
I mean, in summer, I really would like to call out the need for
Oh, wow.
middle income workforce housing and senior housing. 'Cause we know it's a
I
need.
agree, but I think we have to be in line with what the state is calling it. I mean, we've been calling it workforce housing
But there's a difference
for
between
years.
the-
I don't know.
There's a
you know.
difference. So workforce housing typically goes from that 80 to 120%, where low income housing goes to 60 and lower percent. And so they're different funding. And so it's, if you're gonna go for all state and federal funding, the 60 and below is what you need to do. There's not as much incentive to build that. And that's where that 25% comes in, because you have to be able to offset the lower rents charged for those units that you're not, but the cost of building is still the same. But those are needed. We know those are needed. Our workforce has been saying it for 5 years now, that they don't have the workforce they need. And because we don't really, it's not easy to get here, and really busing isn't great. We've never been able to achieve that. So it's a need here, and people want to live where they work. And we also know, and so I'm hoping this housing study shows, I wonder how many of that 10% of those living in poverty are people who are on fixed incomes, who own their home and have just aged in place because they have nowhere else to go. And I would say in Warren, considering our median age is 50, I would say a lot of that 10% is coming from that population.
So in above, one of the bullets addresses the housing need assessment, so, address local needs for specific types of housing units, so that has not been completed, so that's where we're referencing the housing needs assessment, and that could be, once that's
Which is where
completed,
that
we
would fit in,
You
yeah.
could then, modify some language, incorporate some language from that into your comp plan. With that specific analysis. But I know you had talked about, wanting that higher percentage of low-mod units in housing, proposed housing projects as a preference to, like, you want to reflect that preference in the comp plan. So this was the language, and just, I wanted everyone to see it, see if you're comfortable with that, or if it should be modified.
So once again, I would just, throw out there that, just with 10 years. The plan's
Yeah,
10
10-year
years.
plan.
Just keep in mind that this is our guidelines, it's not Bible, so, I think about 5 years from now, I think we can't do amendments, but in fact, if we get multiple situations where it's 100%, we got, they gotta turn around, and
Yeah.
just point right to this and say, hold on a second, your comp plan says exactly this, and this is what we're presenting, we'll have some type of pushback, I think, at that point, although we're in a position of disadvantage, although it might work today, because the numbers are so low, technically, it may not work in 4 or 5 years, and just be careful what you put in there, because, again, this is certainly referred to, use, and we're making our decisions to either approve or deny,
Right.
So do you have any changes you would make to that last bullet?
I don't, I mean, it's, you know, it's whatever. the-
No, but I mean, based on-
I just-
yeah.
just that, you know,
What
it's
put it-
great if. I just be careful with the.
I would take it out.
If so he's saying, yeah, not a legal concern, but that if an application comes forward that you don't like, that's 100% affordable, they're gonna look at this and say.
I
you
mean,
said-
Yeah, they already can do
saying
it.
You want
but-
100% affordable, so our project's consistent with your comp plan, so.
Yeah.
So let's
that's
take
a
that
concern,
out.
a Caution, you know, that you don't know what's coming, you don't know what the. project
So let's
is.
take that out.
Yeah,
Nonprofit developers typically include 100% LMIH, which would advance the town, so we don't, I mean, to me, that would be encouraging that, and you're saying, if I,
If that's the case, it's a
It might-
policy decision. If you-
Yeah, but I don't-
I know that, man. I'm just saying.
So I wouldn't, I mean, my thought is that like, you know, today, right now, in some parcels, we would love to do the 100% because it works well, but we don't know what tomorrow is gonna be, what the need's gonna be tomorrow, and we may want to have a more mixed approach in our developments, and we would be almost directing everybody that comes in that our preference is 100%.
yeah, well, that's what I'm saying, maybe we should take that sentence
I
out,
think we should
Yes,
take it
I
out.
agree. Take it
Yeah.
out.
let's take it out.
'Cause I'd like the idea of more mixed.
Yeah, no, I think that's, that absolutely makes sense.
So do you want include a high percentage, the more general statement?
Yeah, I think
there?
that's what I was looking at, sorry, it's not probably crossing the line here, but the first sentence, I think is okay.
Yeah.
It doesn't lock you in, but once you start to put that 100%, I really think it legally will have implications.
Cause I think this is getting to the point, at the end of there saying, when requesting substantial relief from local zoning
Yeah.
regulations. So that's
Right,
kind of saying,
right.
like, there's some
So,
developers.
high
who
percentage,
would
yeah,
only
that first
include a couple,
sentence
but
is
they're
okay.
asking for the maximum relief on everything, so that statement, I think, there's a consensus there that you weren't,
Yeah.
happy.
It
with
almost
the
says
plan.
100% is the town's goal.
Yeah,
You know what I'm
right,
saying?
and we don't,
They were just-
no, absolutely not.
Not to mention nonprofit developers. The other thing is like they don't pay property tax and they don't pay tangible tax as a business, so we get zero tax income from them. From a nonprofit. And
They have
They
they
pay-
pay a
they
property
pay
tax.
an
but it's different.
8%.
They like
no,
that.
they pay 8% of employment payroll tax, which goes to the state and federal government.
Well, I think they do pay 8% of the receipts of the
Nope,
Of the
nope.
rents.
rents, yeah.
Yes,
The 8%
yes, that's
tax
what they
credit
said.
Based on the rents and an average of the total rents. Yeah.
That was the testimony they provided.
Because he said
Let's
employment,
not talk about again specific. I'm gonna get uncomfortable about.
yeah, so
Okay.
employment tax of the 8% employment tax is your payroll receipts of your employees. But that isn't a municipal tax. Municipal tax is property tax and
They do, the particular projects do pay property taxes, but their formulation is different than normal property. In the particular case of a 8% tax credit development, they do it based on the rents that are generated. And 8% of that is paid in lieu of property taxes, the way it's been normal.
so it's a pilot. Payment in,
No, it's not.
it's
So-
a
All right,
pilot, but
we
it's a
need to
payment,
move
a
along from
payment
this
in lieu of
because under
taxes.
the-
No, this is.
No, it
important.
is not. It is
Under
tax.
the
It is-
advice of the town solicitor, I think,
No,
you
but
know.
we're just, but we're talking about like just in
general.
general, and so, and Herb and I had talked about this because I was wanting to understand this further, and so I looked, read the statute myself as well, and it's exactly as Herb says, it's 8% of the revenue that is generated through leasing it out. So it would be it's like income tax that they're paying, but it would be in lieu of, that would be their form of their property tax. And then if it was a for sale, then that would simply be as it's assessed, but I would imagine the assessment that the assessor does is gonna incorporate the property type in coming up with a value to determine how it's
And
assessed.
that it's,
It's in their minutes that
Yeah,
when
but I
they
mean, in-
responded to there was a lot of concerns.
All right,
Right,
let-
but-
okay,
Okay.
that's it.
Saying
We
they
talked
would
about
pay
enough.
8% of
We
effective
said it.
gross income.
We're done on this particular thing, under the advice of our legal counsel, so, you know, like. It's not go cuckoo here. So we're now down to 62, where, I mean, the charts there, I don't think there was anything particularly important for us to
The
address within those.
implementation, oh, no, it's just data background.
Right.
Yeah.
So remaining elements, chapters 7 and 10.
Yeah, so just incorporate, you've already reviewed all those, I'm just finishing up,
Yeah.
the comments, incorporating like the state.
Now,
values
should
again.
we, so, you know, our goal is to get back to what Herbert asked initially is, you know, we'd like to say this is right for the town council. In your opinion, I mean, based on our discussion tonight.
Rightness is defined by a majority vote of the.
But again, and I think the question is 7 to 10 are, you know, chapter 7 through 10, are those are elements?
Yeah.
that we've
those are the
gone over.
remaining elements. You've already reviewed them and, you know,
Mhm.
have blessed those, but I just haven't inserted them
Right.
into this document and I'm just finalizing that state guide plan narrative at the end, so.
Can you send those to us? I mean, could we, you know, I'm trying to facilitate this process.
So it's transportation, economic development, land use.
Are you
We
saying
just
send them to us right
send it
now?
to the
Review
town
right now?
council.
Review right now?
No,
Oh,
no, Allison's got to formalize them,
Right,
but I don't necessarily want to hold up the process.
right.
Because we've already gone through these at least twice, in some cases 3 times.
So
So,
the chapters that are 7 through 10, I pulled up the table of contents are transportation, economic development, services and facilities, and land use. And then implementation is in a separate section. Have they reviewed implementation yet?
That
Yeah.
was
Or is
not-
they-
Yeah,
it's all,
Okay.
yeah, it's nothing
It's
new as
table.
far as, except for that introductory paragraph,
right,
the page that's here, but it's all the action, it's all the tables that were in the elements. Yeah.
Okay.
We talked about how we were gonna,
Although what I did was
Shuffle.
highlight, let's see, well, again, this is a formatting question here. We had talked about, this was in that implementation program introduction statement. We said that calling out the action items that were market to Medicom, you know, came from the market to Medicom plan. So I went through your actions and highlighted those that were from that. And the original concept here was to use that as the backbone of this comprehensive plan. So I was, you know, trying to tie that all together by highlighting those, calling those out. And then there's a requirement that if it's a public facility, new or renovated public facility in your your CIP, that I found one, I highlighted that in a different color and that's described. Also, that's explained in the implementation program introduction.
Oh,
It's the new rescue station, I believe. Not rescue station, that sound right? Let me look.
yeah, I mean, I think what we're going to, as a result of this recent,
Building.
Oh, they're
Training.
consolidating the fire and rescue.
as a result of the recent settlement and the how that's impacted the town's finances, that will
Rescue station.
it directly impact some of those kind of, nice to have or possibilities of things. So that's something that, we are probably gonna have to address. It's similar to the town's affordable housing trust. It's no longer exists. Doesn't mean that it couldn't come back tomorrow with a grant that serves as the seed money for it. But that is a factor right now with us, that the funding that we were anticipating for service and facilities is certainly not there right now, and not for the foreseeable future. So those priorities may need to change, or, in terms of timing.
And
the
maybe that's
timeframe.
something that when you have that joint meeting, kind of the council can
Yeah.
weigh in on that and.
Yeah.
Make some.
I'm not saying change anything now, I'm just
Yeah.
saying, we need
Because
to
as
be
of
aware
now,
of that.
right, it's budgeted, for, so.
Okay, well, then I would say, this is, now, if we give this to the town council, we would meet with them in a joint session, giving them sufficient time to review it.
Yeah, I would hope so. Yeah, so what I would like, my recommendation is let Allison, if you decide to, push it forward. Let's give Allison the time to get this all literally into one document from that standpoint. So she's got, for instance, adding in chapter 7 through 10. Get the final tweaks done from what we talked about tonight. Get that to the council. And jointly, as I get that to the council, get them to schedule, at least as part of one of their regular meetings, a joint meeting with you folks. I would like it to be separate so that they don't have other agenda items disturbing their thought, but whether I can do that or not is.
Well, we could certainly make that request from the planning board. Yeah, I'd be happy to work on it.
It's, implementation is a different beast. sometimes,
Yeah,
but-
what do you think in terms of timing?
I think it's probably, putting
March,
10
April?
people in the same room, I think it's gonna be, right, probably more the March timeframe, depending on Allison's schedule from that standpoint, and getting stuff in, but basically, at the earliest would be their, say their March regular meeting or special meeting in March.
Or April?
Yeah,
Within that.
and then I think what, once you've passed it off and you've agreed in that joint session that you guys can go back home and they're gonna take the beast. I'm assuming they will take a meeting or two to be comfortable with the document in order to warn it for public hearing.
And at the public hearing, that would be before us and them, or?
It's just them.
No, they have to hold the public.
They have
hearing.
to, or you.
Or you can do a joint, so planning board has to hold a public hearing and the town council, you can do a joint meeting where they both adopt.
So it'd be two joint meetings in reference to this.
Yeah.
Okay, all right.
Yeah.
Well, could I have a motion to move this forward?
So I'll move that we submit the plan as modified tonight to the town council.
Including 7 to 10, which, yes, verbal.
And you'll have a meeting before, potentially they'll have another meeting before, it goes before.
Yeah, I think before it gets all the way up to the council, I'm sure you'll have another regular meeting, so if there's something that we have to throw back before you, we will.
Okay.
But the idea is not.
All right, so that's part of Haley.
So, but would you send us a copy of the revised plan? That's,
Absolutely not.
Yeah.
I hereby request.
You see how,
So we can have the full document, read, like, I can incorporate everything,
Yeah.
the maps, those remaining elements, and have that out like right next week, and then knowing in the background, like formatting, like that kind of the document, not changing text, but just that can go on and finalizing the state review as well. That's going to be happening while you're waiting for those town meetings to happen.
And the state wants pretty pictures and graphs and charts.
Right, so
Okay.
but at least you'll know your content finalized with, of course, any changes that are gonna occur during the review process.
all right, so
Your
the motion,
agenda, if there are comments, like you know, there's nothing that's gonna be presented to you new, but you'll have the opportunity potentially, you know, we're about to put that on the agenda, just since you'll have the full document, if you have some minor tweaks at that point, if you wanna change.
So the motion then is to move this forward with the goal of presenting it to the town council at a joint meeting. You know,
Yeah. When the
okay,
council-
so
yeah,
that's
fair.
so moved. Second? Terry, all in favor? Aye, those opposed? Okay. Whew.
Thanks. It's a big step for you guys.
Yeah, it is, I know, I mean, it's well, it's been 5 years.
Not me, 5 years. now.
No, but for me, five or six. No, it's been reality. I mean, it's been going on for 3 planners.
Well, most towns take multiple years. Yeah, get through this and update it, so.
Well, the good news is we finally landed on you, Allison, so. Okay, next on the agenda is, our, policies and procedures. The monthly report from, and then planning board policies and administrative procedures, which Herb put together, and I'll let you take it away, Herb.
Thank you. So basically, I just, it wasn't part of your report, but I just found out at literally at 5 o'clock today that, the Jamil's Park, Living Shoreline and Landfill Closure Resilience Project, which is Jamil's Park Phase 3, was just awarded, $1.25 million from REEB. That is in concert already with the $400,000 that we got from SNEP, Southern New England Environmental Program. So all that we have left to hear from is RIDEM with the Brownfields grant that we have out there. If we get the full funding for the Brownfield, the $2 million project will be totally realized through grants with a net no cost to the town. So
Wow.
that's huge for today. Basically I prepared my January 2024 planning director's report. It's looks like the familiar, just trying to keep some of the categories the same with the comprehensive plan and planning board applications. I mentioned earlier the Crowd Street's back in the door for that 12 units, 3 of which will be affordable under a comp permit. For the wastewater treatment facility, there are some improvements that we've been trying to do there for quite some time. I just submitted a $2.5 million EDA grant to do electrical upgrades and resiliency as part of that project. So hopefully they have some supplemental funds left over from 2023 that we've applied for. I'm trying to do that without a match if possible. I think we will be required to have a match, but what we're trying to do is shift some funding from another grant source that hasn't gotten off the ground yet to serve as the match. So I'm still in discussions with EDA on that. Other stuff, just we did receive an award for some technical assistance that will be the foundation for trying to put together a urban forest plan. So that work will basically, the technical assistance we'll get from the state's consultant essentially is looking at our tree ordinance and reworking that, doing some canopy mapping and analysis, also getting some technical assistance for the tree warden and the tree commission along with the DPW director related to our street trees. So we may get an updated street tree inventory and best management practices for that. So that's kind of cool stuff. And then ultimately the implementation of that is an urban forest plan that looks at our capital improvement plan, maybe update our ordinance, and, on trees. And then also, looking at, a better, what they call the green infrastructure complete street plan, which is, looking at things that actually kind of that are sort of climate resilient, climate change type issues. The green infrastructure helps bring down the temperature of streets from that standpoint, and makes things more neighborly in addition to the climate change resiliency stuff. I'm just trying to quickly go through the highlights from that standpoint in terms of that. The rest of it, I'll just leave for now, as if you have a question on it, I'll entertain some questions, but it was in the packet, so if you've read it, you understand what I'm talking about. With regard, so that's it for the monthly report, Mr. Chairman. Do you want me to, if anybody has any questions, or I'll just dive right into the rules and procedures? So, recognizing the time, I am still working with the solicitor to go through this, but I wanted to give you some highlights of what I'm trying to do. Basically, what are your policies and administrative procedures? They're your operating bylaws that you go at. And when you meet, what constitutes a quorum, what time you meet, what's your paper of general circulation for notices, that sort of thing. So I'm trying to do a general update. For instance, I'd like to see the term, wherever we have like chairman, or from that standpoint, I'm trying to make that more generic to just say chair as a, for instance. So there's some general changes that I'm trying to do with regard to that, to if you will, vanillaize some of the language. And then sorry, I'm just flipping through things, that making sure that where we properly cite the Open Meeting Act, that those citations are in there, updating your membership, just to validate that you're 7 members with 2 alternates, and essentially just, I'm making sure it aligns with the charter, because the charter kind of dictates a lot of the procedures for you from that standpoint. But your quorum regulations the voting structure for a development application has changed since these were originally adopted. Originally, when these were adopted, to approve an application, it took a majority of the full membership. So it was a majority of the 7, no matter who showed up. If you had a quorum, it still had to be a minimum of 4 people voting in support of a development. That law changed a couple years ago, and it took effect last January, where now what happens is as long as there's a quorum,
It's the majority of the.
it's a majority of those present and voting. So if you think about it, 3 members can now pass a development, which is a minority of the board as a whole. I don't like that law, but that's the way it is nowadays from that standpoint. So just recognize that as you move forward, but I'm trying to make the changes as applicable here. Again, you basically have changed. You used to start at 7 o'clock. Now you start at 6:30. So that changes the times throughout for instance, the limitation to the end of your meeting is really 10:30 and not 11 o'clock at night. Order of business, just trying to do some general update with regard to that. The most important thing is really
Before you go,
Yes.
if an application is not going to begin before 10 PM,
Yep.
I'd change that to 9:30. And even that seems late to me for,
Well, he has language in there that like allows some discretion of the chairs.
no, but that's in terms of extending the meeting. But I wouldn't want somebody to come in and say, hey, wait a minute, you didn't start hearing me until 10, I should be heard at 10 o'clock. I don't want to start hearing somebody at 10 o'clock.
Okay.
No, I get that. I'll add that in, and then you guys can talk about it.
Yeah, I mean,
Yep. Okay.
Great.
Where I really want to focus some attention, well, obviously, when we get into a little bit of your pro forma, we've created that one sheet piece of paper that we have out in the audience when it comes to when there's public hearings or in a development application, the process that you go through, that part of that is actually in your operating bylaw. So I just want to make sure that we're in sync with regard to what you want to do and how we typically go through the process of review. And then the biggest thing, the reason why I opened this up originally was specific to technical review committee. The statute defines and dictates certain things, but a lot of what you folks have taken for granted is actually part and parcel of your regs underneath here. So not trying to change that, but trying to go in and make a level, your technical review committee, the way it's currently set out, is pretty broad and undefined. So basically you have me as the chair, the building official, and Fred, the chair of the planning commission, as your members. And then the other membership is to be defined by the planning board. That's fine. But when I'm sitting in the middle of the technical review committee and I don't know who the other members are, it's very hard to entertain motions and stuff when I don't know if I even have a quorum to sit down at the table. So what I'm trying to do is to further solidify your operating procedures as it pertains to the technical review committee to help to define those things when I sit down. So some of this is not, I'm not yet wedded to it. As a, for instance, I really need to have the DPW director as a member. I want the town solicitor as a member, but it doesn't make sense in the grand scheme of things to have the town solicitor as a member because they have to remain objective and apart from that. So I would like to have them there attending, but not as a particular member. But for instance, volunteer historic committee. They've had a high level of participation in a couple of recent cases. I think that it's acceptable to have them as a member, but only when it's in a historic district or it's the other, it's what, 100 years or the building's 100 years or more. So that kind of qualifier that would say they're a member, but only in certain circumstances. Beyond that, they would just have to continue to provide any recommendation to the planning board as a whole during the normal review of the development.
We had also mentioned the comprehensive permit, the fact that
Correct.
the planning board is acting on behalf of the
Correct.
historic
There's some
district.
qualifiers that I might want to have in here as it pertains to the technical review committee. And if there's anything that's a little bit different, because when there is a comprehensive permit, and Fred is, accurate, is that you folks make the decisions from that standpoint. You don't have other boards doing reviews of certain things. So they might be able to, again, just like we did with some of our previous applications, allow them to make a recommendation as part of the normal process, but they technically don't have a review on their own under their normal process. It's all done under your umbrella. So I have to be careful, in my opinion, in terms of a TRC when it's triggered, whether we're in a comp permit process or just a regular development review process, as a for instance.
So on the technical review committee, I saw that you added in and then struck out the N1 member of the planning board. So is there, I know we have Rick's on it now, but is there no requirement to have a planning board member?
The law, the enabling legislation allows for planning board members to serve on the technical review committee. Personally, I don't really want planning board members on there for risk of ex parte communication. That there's a member of the board that's actually acting and participating outside of what would be the process, the normal process of that review, and that person is being given information and participating in a situation that's outside of the other members in your normal process. However, as much as that would not fly in Vermont, down here in Rhode Island, as long as the chair, or in the instance of the TRC minutes, are provided, in other words, the member can provide what they heard to the commission as a whole when they meet, or the board. Similarly, it could just be done through the advancement of the minutes of the TRC to the larger group. before you close the public hearing and all that stuff, so that all members have advantage of all the information that was discussed. That's permissible under Rhode Island.
The fire chief and the police chief, members of the TRC?
Basically, what I would like to see the TRC be really are some of those key department heads that have the most impact when a development comes in from that standpoint. DPW, police, fire, obviously, my office, I'm already involved. Matt's already dictated by statute with regard to zoning and all that. I think there are certain situations where, you know, Tara, as for recreation, would be important, but not always. It's kind of, you know, she's one of those not always type things. Same thing with police and fire, not always, but there's a little bit more there because of the potential of something happening in an emergency situation. And then there are other department heads that, as a, for instance, town clerk doesn't need to be as part of that process. It wouldn't be necessarily impacted. So that's something I'm still trying to weigh. I don't want to have so many people that it just becomes this big cumbersome thing, because there is a internal process of letting department heads know that an application came in the door. And if you have concerns or issues with it, please let her know, right? That kind of stuff is in. So this is, the TRC is kind of formalizing that. And that's, I agree with that. And I think that's a good way to do it, because a developer or an applicant, when I'm hearing something for the first time, they're hearing it for the first time as well. So we're all in the same room at the same time frame, same ears and eyes are hearing the same thing. So oftentimes that's a great place to explore trying to work something out if there's a particular issue that's there.
Herb, the pre-planning, which has been a helpful tool to us, would that take place prior to a TRC?
So the law has changed such that master plan has gone away in a comp permit. I'm still working with, for instance, there's an application in the door that they purposely came in asking for master plan rather than preliminary plan, because they don't want to heavy load do the heavy engineering that's expensive for the applicant until there's some level of insight.
Oh, no, I'm
provided by the
sorry,
planning
I used the wrong term. A pre-planning meeting. You know, in other words, we would have, there's a pre-application
Right.
informal concept
Right.
plan.
So I was getting to.
That's what I'm,
So,
yeah, no,
So I wanted to preface my answer
I
to
see.
you in that the new comprehensive permit law actually did away with the master plan level. So you go from pre-app to preliminary. There are a lot of engineers that don't like that because they think it's burdensome to their applicant, their client, to basically say, in order to get before the planning board,
You
you
gotta
have
have
to do
everything.
all your heavy
Right.
costs. So what I'm trying to work out internally, and this is discussion I still have to have with Ben as a, for instance, is to say, can we design our process so that the pre-app technically is the master plan? They won't get the vested right that you normally had from that standpoint, but at least have an application come in that's got enough information to it so that it isn't just the pre-app and a possible picture on the back of a napkin. It's got at least, you know, 1 or 2 pages of a plan that's put together that normally would have been the master plan review, but will now just be considered pre-app.
Would that come before or after the TRC?
That would come before the TRC.
Right, because that makes sense to me. I mean, that has been helpful in terms of
Right, the
talking.
TRC now would be triggered at the preliminary level.
Is the pre-application mandatory or not?
No,
Okay,
it's not.
so somebody could conceivably say, I just want to go to the TRC.
Yes, but our regs talk
Well,
about,
they have to go. to
our
the
regs
TRC.
talk about a pre-application process, but I think if an applicant really argued the point, under the new law, they might be able to just come before you right to preliminary without a pre-app. I would strongly encourage the applicant not to do that.
Right, but they would have to have a TRC prior to.
They would have both whenever there's a preliminary plan and a comp permit submitted, there will be a TRC.
Right.
So I will make sure, at least as long as I'm here, there will be a
Yeah,
TRC.
no, I hear you.
Yeah.
And Herb and I have talked about whether a planning board member should be there, and I think, you know, one of the concerns there clearly is we're the group sitting in judgment on that. And, you know, the drawback to me to not having a planning board member there, and it doesn't have to be a voting member, is that, you know, we've got a lot of new department heads and, you know, even our planning director and soon a town manager, you know, so there's not a lot of, you know, institutional memory. And in some of these TRCs that I've been
That was
sitting
my
on,
concern.
you know, it's important to know, okay, well, here's some of the precedents that have gone before in terms of planning decisions, and people may not know that. So, you know, Herb and I talked about, you know, having somebody from the planning board conceivably there, but not as, you know, an integral part, because the.
Right, that's what I
really-
was wondering, like, because there's gonna be things where you know that we want to know this information at that meeting, and someone may not ask it. When we're looking at the TRC, we're like, oh.
But it's a bit of a tightrope.
You
because-
know you are going to ask the right
Right.
questions, you know, but like, so.
What I'm trying to do for the TRC, I mean, my strategy in that whole thing is to work with the applicant and their engineer, assuming that they're there, to basically identify what issues that we may have, at least up to that point, and to see if we can't work through them. And worst case, just agree to disagree on what we can agree to, right? And then that, to me, helps in terms of the report, the recommendations that I draft up for your consideration. The idea being there that no matter how many conditions are in there and how lengthy my report may be, as you know, they are lengthy, is that the applicant already knows about them. And probably most of them they've already agreed to, or at least understand those are going to be conditions that are going to be imposed upon them. So it's not a surprise when they walk into the planning board meeting. So when you get to the planning board meeting, the biggest surprise, the biggest things that you should be talking about are where there may be agreement to disagree, the remaining points, and or what points are raised by the public that may not be incorporated as part of the staff report already from that standpoint. So the idea is to try to channel or funnel what you actually have to talk about as part of an application process. Even though everything is fair game to talk about, what I'm trying to do is at least make your job as easy as possible by whittling down the issues in advance.
And also to make it a technical review. You know,
Right.
this is, at a couple of the technical reviews, there have been comments made by other committee members in attendance, and the applicant mistook that comment for direction within the TRC, which is not what we're looking for. You know, I mean, a technical review is a technical review, what it says, you know.
And when I talk about recommendations to the planning board, I don't talk about recommendations as this should be approved or this shouldn't be approved. My thing is to say, based on the application of record that you're going to be reviewing, if it goes forward, here's what needs to occur in order to go forward.
Yeah, and it's that's why I think, you know, and I agree with Herb, this is why it's difficult to have a planning board member there, because you have a tendency to want to say, wait a minute, you know, do you know what you're talking about there?
Yeah.
And that's stepping out of the realm of the TRC, so,
I had one other question on here, when I was reading it, regarding the language on recusal. It,
Yeah.
Like the code of ethics talks about recusal being for a financial benefit, you know. Our language, and I know it's not yours, it's the Middle Act, it was pre-existing. It says personal and financial. And in a town as small as ours, I didn't know whether we wanted to have something as broad as personal, because like the odds of us having a personal intersection with somebody applying something is possibly.
But that's the key.
Right.
That's the key, is that it's identified. So
But so the.
it doesn't
way
matter
that-
doesn't matter how small the town is and how small the population is. And
But that's not what the state
But
says.
the state, the state's recusal or the
It's
ethics
specific-
commission is specific to financial or pecuniary interest.
Yeah. And so, and like, initially I was thinking, yeah, it should be just that, but then I'm like, I can see how there could be, you know, things that are.
The-
I just almost wanted to know, like, rather than saying, oh, no, let's do exactly what the state says, with respect to that, I think that there are some things where you could see that there is a personal potential
The
problem, but
There's
how do you?
probably case law that Ben can quote that's beyond even just the ethics commission
Right,
that's rationale or threshold points requiring recusal. When I'm trying to do recusal, for me, it's not just the financial stuff, but it's also the person, if you've got some relationship or whatever it might be. The key in all of this is it doesn't necessarily discount you or require you to step away, but it should require you to at least bring it before the larger group, before the discussion on the pending matter is at hand, to say, this is what's happening with me. I'm identifying it for the record. If it's not a financial interest and it doesn't meet some of the other thresholds, it should still be identified. Just like Mike said the other day, I was out of town for this meeting, but I've reviewed the minutes. I've looked at the tape online from that standpoint. As a result, I believe that I can act in good faith in terms of the application before us. And unless there's a challenge to that, the board is going to see fit that, yes, he's okay to do that. The same thing could occur with a situation where I had a business relationship with this person 30 years ago, but I no longer have that relationship. I'm identifying it for the record because I did have a financial interest at the time, but I no longer do. Somebody may say, for whatever reason, you may not have a direct financial interest today, but there may be an indirect thing there because you had a financial relationship with somebody and therefore you may provide favoritism to that individual that you had. Or you may say, because of 30 years, I don't have this anymore. I don't have that. You're leaving it up to the board to decide. That's the key, is get it out into the open and discuss it before you get into the actual application of the matter.
okay, perfect.
All right, so you'll further tune this up and we'll take a look at it again. I'm assuming. One part of it was the election of officers. We noted that Jim Leffers is gone, so we figured we'd put the election as noted in here off to our February meeting. And I think that's pretty much it for tonight.
Yeah, just for the record, so if people are listening, there's one full-time vacancy on the commission, board, excuse me. I'm still in Vermont. We call them planning commissions. It's planning boards down here. But so you have one opening for a full member and you have two openings for the at-large, because your other member that has been ill, I was able to get in touch with, and he's stepped away from that. So if there is anybody out there that's interested, I know that your member of the public that's out there right now has already filed application, but appointments haven't been made yet. But just want to make sure that people know that.
Great. Okay. Well, with that in mind, remember that we have a special meeting scheduled for 5:30 on Monday, February 12th. And with that, I'd ask for
That doesn't conflict, does it, Haley? Do you know?
Mondays are pretty good.
Okay.
no. Sorry, I mean, no. I didn't mean to be abrupt. No, because I was told that.
But it was advertised, Mr. Chairman.
It was advertised. I don't know, but
Well,
it was advertised as public comment.
oh, it was.
Yeah.
It's on our
Okay.
agenda.
Well,
For items not on the agenda.
Retired.
okay. I mean, again,
As long as it wasn't about anything on the agenda.
No, I thought we were talking about public comment relative to what we had discussed.
No, just generally speaking.
Oh, okay. Yeah, go ahead.
You got to come up to the mic. Yeah. Thank you.
So if it was an item that you was on your report, I can't comment on it, or I can?
You can comment. Sure.
Okay.
I entertain all kinds.
Okay. Urban Forest, having been on the tree commission, the big issue I had was the state roads, and we can't get trees on them without Byzantine stuff with DOT.
Yep.
And is there anything that can be done with that? That would be great.
Yep.
Um,
Good point. Yep.
would the planning board, would the town ever consider, as a opportunity for housing, single room occupancy rooms? And I'm not asking for you to answer that now, but this would be like boarding houses, or for instance, convents being converted to single room occupancy. It's a wonderful strategy to help very low income homelessness, and we do have homeless people living in town. I don't think that's in the code right now, and I just wanted to put it out there as an idea. Transferable development rights is something that North Kingstown uses. If someone has a project that they want to do something here, they can, if they want to do something big here, they can transfer some of their rights to another part of town, and they've got target zone. So there's already a town in the state, and I think there is enabling legislation to support transferable development rights, and I'm happy to help with that. I was wondering, with the comp permit 10-acre thing, density, is that applied to usable area? Does it exclude anything? What does it use?
I wouldn't get into that.
Okay, that's fine. That's fine.
It's right in the statute, just.
Okay, I'll look at the
Yeah.
statute. I'll leave the rest of it. I just wanted to
Great. No,
put those
thank you.
thoughts out there for.
Yeah, I forgot all about the fact that we have a public comment because there's so much public comment.
Thank
But
you.
thank
That's
you,
awesome.
appreciate it. Yeah, and the transferable stuff is interesting. And also, no, we had not considered at all, the single room
I think that was actually
occupancy, so.
one of the changes. I don't think it's allowed, or it doesn't
But
count
anyway,
towards
well-
your affordability anymore. It's a 2023 change.
I met with June this past weekend, and Jason tonight, and, Laura will be like, when they were reaching out to the community, and June mentioned that one of the things that she's going to be starting looking at for the legislation is also the SROs.
Yeah, because it like specifically said in this year that does not count, which doesn't really make sense, but
Okay, so a motion to adjourn?
motion.
I'll make a motion to adjourn. Second, Mike, all in favor?
I'll second.
I'm sorry.
Who made the motion? Was it
Ashley made the motion.
So no,
All right, and who
I need a
seconded
second.
it?
Mike,
Mike,
and we all voted for it.
yes.